A verdict expected soon in the dramatic court battle between the family of Michael Jackson and the King of Pop's last concert promoter. A lawsuit filed by Jackson's mother claims that promoter, AEG Live, was negligent in hiring his personal physician. That doctor later convicted in the pop star's death. So what can we expect after 58 witnesses over 83 days of testimony? Let's bring in our legal panel, Robert Schalk and Doug Burns. Both are defense attorneys and former prosecutors. And, Robert's going to be with us in just a second. A little trouble with his audio, I think. But, Doug, let me start with you. Doesn't it all come down to actually who hired Dr. Conrad Murray, who, of course, was convicted of involuntary manslaughter?
Yeah, you totally read my mind, Greg, because I was going to say that we lawyers, trial lawyers, we get into so much detail, so much minutia in the courtroom, this memo, this date, this, that. But this jury is going to be focusing on one thing and one thing alone, which is exactly what you just said. If, in fact, Michael Jackson insisted that he be hired, then it's ball game over. Yeah. The idea that AEG, on the other hand, really hired him, to me, is a bit of a stretch, honestly, because it seems to me from the evidence that I've digested, that the King of Pop, being as huge a superstar as he was certainly going to have a lot to say about which doctor was going to be hired.
Well, there are factual issues and legal issues for the jurors to sort out. And Robert Schalk, let me go to you on that, because I was on a program a few days ago, and because I tried a couple of cases in L.A., I was asked, what do you think of this thing? And I thought, the last thing I want to do is represent a rich defendant like AEG in front of an L.A. jury, because I'm not sure they care about the facts and the law.
Right, because you have to take into consideration venue is sometimes the most important aspect of a case, whether it be criminal or civil. They always say, possession is 9/10 the law. Well, 100% sometimes of the law is, and where we are is what courtroom we're in. And you know best, Greg. I mean, you were out there. These are the types of cases in which you have a 21-week case. Okay, you have to think about what jury pool you're going to get. Who's going to be sitting on that jury? Someone potentially from the middle to lower income classes that can sit on these jurors for longer periods of time. Those are the people who are going to say, the business being $1 billion company, and what's a couple $1 million out of their pockets and put it to Michael Jackson?
Let me play one more clip of closing arguments, and we'll get back to you guys. Here it is. Take a listen.
Mr. Trell and his other lawyer friend referred to Michael Jackson, who they're entering into a multi-million-dollar contract with to build up their arena, as a freak. That's how they think about him.
Plaintiffs want you to hold a concert promoter liable for Michael Jackson's overdose in his bedroom at night behind locked doors on June 25th, 2009. Now pause on that for a moment.
Even Michael Jackson's ex-wife took the witness stand, Doug, and said, he hid his longtime addiction from everybody, and he was skilled at doing it. So in the end, might jurors conclude Jackson killed himself, personal responsibility?
No, I think, honestly, when you formulate the two sides of the rhetoric, and the lawyers did a good job, one is that it was hidden from everybody. We had absolutely no idea. The other side says, come on, you have to be kidding me. There are emails saying that he's a freak. I don't know that the word freak semantically equates with he has substance abuse problems. But at the end of the day, I think the way you put it wins the day. I really do, Greg.
Yeah, you know what, Robert? California used to be, back in the day, a contributory negligence state, but now it's comparative negligence. So isn't it possible that these jurors may reach a compromise by apportioning fault to each side?
Absolutely, especially when you take into consideration the fact that there's known testimony from various witnesses that date Michael Jackson's drug abuse on propofol back to the early 1990s, and he was asking doctors to work with him, and doctors turned him down, saying you shouldn't be taking that type of medication. So I think it's abundantly clear that Michael Jackson definitely had a say as to who was going to be working with his medical team. And not only that, AEG put forward that we told him, we have doctors for you in London. You don't need to bring your own doctors. And that was a big sticking point for them. He wanted to have Dr. Murray or a doctor of his choice working closely with him because he knew exactly what he wanted.
Doug, we got about a minute left, but let's talk about damages here. Not only, personal personal damages to the family because a loved one is no longer there. But the big ticket item here is earning capacity lost. That could be $1.5 billion, right?
Yeah, but it's kind of a mixed analysis, and Robert and I were talking about this a little bit earlier. I mean, look, the point is the plaintiff is Michael Jackson's mother as well as his children, so the point is it's not necessarily Michael Jackson's earnings per se. I also wanted to throw in quick, Greg, on comparative negligence. One of the lawyers argued, look, ladies and gentlemen, it's like a bicycle built for two.
Right.
You know, either one can be a fault. So they really are playing that card.
Yeah, they surely are. Robert Schalk, Doug Burns, gentlemen, thanks so much.
Thanks, Greg.
My pleasure, Greg.
And that's going to do it for us. A Healthy You and Carol Alt is starting right now.
A healthy you? Okay.
We're back at, I think we're going to be back at 6 Eastern.
Yeah, that's
He
right.
gets me in trouble.
Have
all
a
the
great
time.
afternoon, everyone. Bye-bye.